Any adjournment request? Daily list.
Lordship, I beg to mention item number 12.
Item number?
12. Lordship, these are connected matters and they have already been disposed on 13/2/2025. Maybe due to some error, the matter is listed before this honorable court, but these matters are already disposed of on 13/2/2025.
Okay, we'll see.
Obliged, Lordship.
What listing? What? What kind of matter? Read appeal?
Criminal appeal, Lordship,
Pursue before the registry.
Lordship. Lordship, pray for listing of MAT appeal, Lordship, which was filed on last January only. But there was some correction to be made in the cost title, Lordship, and it is in the motion column, Lordship. Any date, Lordship, next week?
No. It is filed in January.
Yes, January.
Why
but
it
there
is
was-
not listed?
No, it was listed. 2 times it came, but there was a mistake in the cost title, Lordship. We were asked to amend the cost title. We have done this in that on
Yes. Motion column.
motion column, Lordship.
Okay. Look at you. Yes.
May it please your lordship, I beg to mention one criminal appeal, lordship. It is a POXO matter and it is a fresh matter, lordship. The matter may come up in the motion column, lordship. A date
Go to
will
the
be-
registry. If something is there defective, then we can't help it. Remove. All criminal matters are listed expeditiously.
Daily list. Item number 1.
Yes.
Lordship, the matter regarding lordship is a list of discussion. So here lordship, the last question is to direct it, my pen to file an affidavit person.
Hmm.
We got my additional affidavit person.
No. Mr. Das, similar matters came up last week. So we have passed orders to allowing the petitioner here to meet give the visitation right, at least.
Lordship, my grievance is here lordship. So here the father name is not matched lordship. So the here absolute violation are under section 47 of the BNSS lordship. So without
Under section
section 47 of the BNSS lordship.
BNS.
So the without
BNS.
arresting lordship,
Yes, state is not filing affidavit.
Lordship, we are supposed to file.
Yes.
Is it get Lordship? Yeah, we file it. We file it.
Yes, Mr. Das, see this order.
lordship behind the bar.
See this order, not behind the bar. This is not a case of behind the bar.
Lordship, unlawful detention lordship since last 22 days lordship.
Mr. Das, if it is declared foreigner, if the person is a declared foreigner, we can only give visitation right as like the coordinate bench. How much time you need?
So lordship is a different person lordship. So there is nothing-
Obviously different.
no allegation of the foreigners lordship. The father name is different, so that's why I'm raising this query lordship.
Let them file affidavit. How much time?
We file today.
Okay, file today.
Yes, lordship.
You don't need that disorder.
No,
Okay, no, okay. Give that back.
it's a different lordship.
Give that back. What to do? You don't know, need this similar order for a timing.
Yes. Sorry, sorry.
It's not required. Okay. Heard. Mr. R.C. Das, learned counsel for the petition, and Mr. A. Gogoi, learned
Yeah,
government advocate. For all the respondents, also. By the previous order, comma. The state respondents we're directed to file this counter affidavit on or before the returnable date, date is today. So, Mr. Gogoi, the Lieutenant Government Advocate has submitted that the counter affidavit on behalf of the respondents, state respondents, is going to be filed during the course of the day. So, place the case on Friday with the state affidavit, counter affidavit on record, if so filed.
So Lordship, if the Lordship, and lots on bail Lordship, as because Lordship that. And lots on bail Lordship, because Lordship, the since last 22 days behind the bar Lordship, the person is not connected to this.
That is why, Mr. Das, I have asked you to go through the order.
Yes.
Temporary relief, the court has been granting in all such cases, but you decline to look into that order.
I'm sorry.
You decline to read the order.
I'm sorry.
Don't taste.
I'm sorry.
Next.
Item number 2.
This is appeal.
Heard Mr. A. Gogoi, legal counsel,
Not.
and Mr. R. Kosik, additional public prosecutor for the respondent. Number 1, state. Sorry. Off. This criminal bill under section 415 within bracket 2 BNSS is preferred against a judgment dated 9/4/2025 and an order on sentence dated 11/4/2025 passed by the Court of Law and Special Judge Udalguri in special within bracket POCSO number, case number 25 of 2024, arising out of Panay Police Station, case number 50 of 2023. By the judgment and order, by the state judgment and order on sentence, the accused appellant has been convicted for the offense under section 376 within bracket 3 Indian Penal Code and under section 4, Protection of Children from Sexual Offences Act 2012. First of, in view of section 42 POCSO Act, the accused appellant has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000 with default stipulation, under section 376 within bracket 3, IPC. We have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of POCSO case number so and so we call for issue of this returnable in 4 weeks. As Mr. Kosik, the additional public prosecutor has appeared and accepted notice on behalf of the respondent number 1, constituted some issue in the formal notice. The said respondent is dispensed with one extra copy memo of it. The accused appellant shall take steps for service of notice upon the respondent number 2 thus informed in terms of the practice direction. The learned additional public prosecutor is to obtain the report as a service of notice upon the respondent number 2 thus informed from the officer in charge, Panay Police Station, by the next day to this. I had to state of the action 4 weeks. State secrets.
Items 3 and 4 for orders.
Ma'am, please allow us. My lord, yeah, my lord, after seeing the record, my lord, the item number 3, my lord, it seems to be matter pertaining to honorable single judgment. Because lordship will see the penalty part, my lord, lordship can have a look at page 33. I have come against the acquittal. Section 143, 447, 427. Page 33.
Certified copy of the.
So what's the title of looking for? Single page.
It is you who has filed that.
Yes, my lord. I filed this against the acquittal, my lord, since my lord the subject-
Ignorance or lack of knowledge,
ignorance.
or lack of knowledge.
Here.
Ignorance for 9 years, 8 years.
My lord, maybe my lord oversight, it has left out is at 9 years now.
ZR case,
My lord,
right?
my lord.
143, 447,
Yes.
427,
Yes, sir.
right?
My lord.
When double oversight, then thereafter appeal was preferred.
No,
But
yeah.
appeal was disposed of by session judge.
Session just.
So it can't be any appeal.
No, my lord.
And secondly,
No.
it can't be before division bench.
Division it cannot be, my lord. It has
Cannot.
to be
And
single.
it can't be appeal also.
No, my lord. Here, my lord, what happened, the facts?
No, see, facts, come to page 14. Judicial magistrate first class,
Yes, my lord.
ZR case number,
They convicted.
judgment.
Yes, my lord.
Now see the judgment part.
$15 days, some, my lord.
I have therefore convict the accused persons, 143, 447, 427. Criminal trespass
My lord.
with intent to commit mischief. So this accused,
They preferred an appeal.
Hmm.
Session just acquitted them. Against that acquittal, I have come.
so is Mr. Kamar, ZR case, conviction. Accused came before the learned single judge by criminal appeal. They got acquitted. Now, what will be the remedy?
Actually, it will be light, but for him, it will be the first opinion. Because other side is.
And at that point of time, 372 was there.
Which year?
16 note, asking. It up to you.
272 provides you.
372 provided some. কোন সঙ্গে নাহি সেটা?
It is in 2009. Because provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense of imposing a negative compensation, the sole appeal shall lie to the court of which an appeal ordinarily belongs. Within the order of conviction of such case, it will be inserted by Act 5 of 2008.
And what was the punishment there? Initially ZR case.
In your case, 15 days, my lord.
All those were punishable by Chief Judicial Magistrate.
Yes.
Magistrate.
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 Lordship can see, my lord. Page
Then it
20.
can't be before the division bench.
No, it cannot be division. It has to be honorable single judge. That's what I said, man. It has to be.
Or does it
segregated.
sound?
I'm just adding a line where the 376, there is a bar also in appeal to 5 minutes. No appeal in certain cases where accused. No, appeal by state government. No appeal in petty cases. Where the sentence. Can I have a look at 376?
That is by convicted person.
Yes, my lord. Because he was convicted first, my lord, 15 days, my lord. So whether it will come in any of the.
No.
No.
Now it is victim.
I'm victim.
No. First round I am saying.
First round I was the complainant man. Then I.
First round.
আমি informant আছি। Oh, sorry,
First round, he was sentenced.
accused was sentenced.
Accused was sentenced.
Against that they.
After
preferred-
hearing of sentence, sentence for 15 days.
Yes, ma'am.
And they pay a fine rupees 200.
200. Against
And
this
in
order.
default, 10 days.
Yes, my lord. Against this order, they went to session judge.
My lord, I think in E, my lord, whether a magistrate of the first class pass only a sentence of 5, not exceeding 1.
No, here it is,
15 days,
15 days, 200.
here it is
15 days.
15 days.
And 200.
Six. How it came before the division bench?
My lord, maybe at the instance of either side, on our side
No,
or
let
from
us-
the PP, my lord.
Let
There
us
must
it
be
is
some order.
2017, এখন কি case, no? এনে কাহি গ'ল। Huh? How does it take what I said?
No, no, that is stated, my lord. And that one acquittal against us was preferred by the state. Originally, it is. Registered FIR.
Oh,
380, 427. Division নহয় কোনো,
Mr. Borgunia,
my lord.
why the second case is said?
Second is the appeal filed by the state against
State.
us. I got acquittal. They said, my lord, their daughter is missing.
No. In the first case, you were representing Purnima Begum.
Yes.
Purnima Begum is the informant.
The son of Samsar Ali, the next case.
No,
Daughter.
no,
of-
please
My lord.
make me understand.
Lost.
The here item number 3,
Three,
which is of the single bench,
my lord.
the appeal is preferred by Purnima Begum as a
Yes.
victim,
Victim.
definitely against the acquittal.
My lord.
And in the state appeal, now you are saying I am representing the accused who have been acquitted.
Huh.
I have not understood.
Understood, my means the second case is my father, my son, my daughter.
There are two cases or two cases, cross cases.
cases.
Oh, okay.
Cross case.
Cross case.
Cross case.
Let us see what is the cross case. Division major কেনেকে আহিল লগাইছিলে কথা নাই বৰ্তমান GR case
এইটো মানে 183.
342 GR case 342
কৰা গ'ল।
GR case 342
এইটো FIR court.
তাতে পূৰ্ণিমা বেগম ইনফৰ্মেড আৰু ষ্টেটত
FIR to. Next case or FIR to কিমান?
হয়তো ক্ৰছ কেছ ন
Ejahat 45.
GR case 327 prosecution story 28/4/2005 28/4
দিতে আমি তাই দিতে হবে।
পূর্ণিমা বেগম
Third daughter, Monwara Begum. Nutshell is that, my lord, on the day of
Not a cross case, not cross cases,
not the same case,
not cross cases also.
my lord. Yeah, my lord, what happened, my lord?
No, whether it is, these two are cross cases
My lord,
or,
they lost an affair, we lost an affair.
no, but incident is different. On date of incident is different. In that case, can it be termed as cross cases?
No, my lord.
Then
It
why you have
is-
said cross
No,
case?
my lord, I did not see, my lord, now I have seen it.
Oh, you have seen here in court.
No, my lord, this the case, my lord, my daughter,
The question is cross case is different.
my lord, two
And
different
if cross
cases.
cases are there, then it is preferable to try both the cases together.
Together, different
Right.
cases, different cases.
But here are different cases,
Yes,
not
my lord.
cross cases.
Not cross, two different.
Cross cases, if of the same incident,
Incident,
there
that
are
was-
two versions.
My lord,
But here is a case, one incident happened previous day, the
Only
other
the-
incident happened on the next day. So this cannot be termed as
cross.
cross cases, and they were tried differently.
Differently, my lord. Two different cases.
So who has tagged this?
My lord, we have to check up from the record, my lord, because
Paperwork has been prepared. Paperwork is not already prepared. On the request of Mr. Borpian, this appeal be listed along with criminal appeal 222/2016, which is stated to be connected with this matter. This is also oversight.
no, my lord. Not oversight, my lord. That mistake is there, my lord, on my part.
So this is wastage of judicial time also.
My lord,
First you said cross case. This oversight I will attribute to you.
my lord, maybe only simply segregated,
Hmm?
my lord.
No, no, no. Absolutely not. Who is for the state? Hard business J. I. Borvin. Learn it. Counsel for the appellant in 3. When for the respondent number 1, 2, 6 in 4. Miss A. Begum. Learned additional public prosecutor. For the respondent number 1, State of Assam. And for the appellant in 3. And for the appellant in 4. And Mr. Z. Along. Learned counsel for the respondent number 11 in 3. And who else from 2 to 11? And I cannot
Due to 11, my lord,
The-
Lojima code report is there, my lord.
learned counsel for the respondent number 2 to 11, 2 to 10 is found absent today on call. I do. It's just issues. Madam Begum. What is your case in the state appeal? Notice has been issued to 126. Kimanjalam. State
Against
appeal
like-
respondent. Respondent,
State appeal.
1 to 6.
Oh, well,
Mr. Alom. Okay. 1 to 6. You are for all the responding in a state appeal?
No, my lord, I'll just. Only. All.
All. Yes, Madam Begum. Since 2016, 17, you have prepared the appeal. Paperwork is ready. This IA is for what purpose? Have you seen ever? Have you ever seen it? No,
Lordship,
no. Huh?
we have taken lordship.
Hmm.
This record is. The land appeal also.
Good. Ajay Kamar, Learned Additional Public Prosecutor appealing court of state. In the state appeal.
I was doing.
Madam Begum, this application is preferred under section 5 of the Limitation Act, seeking condonation of delay of 86 days. As on that delay is not condoned. And you are not pressing for this. So appeal technically is not born. Your appeal.
Delays to be condoned.
Delay is to be condoned.
And what I see from the paper book, my lord.
Huh.
As they are saying that.
No, I am just, you are there at
No,
that
no.
point of time.
I'm just pointing it out, my lord, again, that this is not for a division bench matter because the maximum is 380.
Which one?
457.
It would see in items.
No, item 4, state appeal, state appeal.
Ah.
I, it, little was.
It was, the charge was under section 302. 364 and 34. So it will be before division bench. Appeal against acquittal. Madam, 86 days. Yes.
In the second case, my.
No, you have acquiesced and waived.
He has entered
It-
appearance also.
And you have
I
by
have received
by
the
not,
notice, man.
not filing any objection for last 7 years, you have waived your right.
I received the.
We
call.
condone. We condone the delay.
I'm leaving it up to your lordship, my lord. Your lordship wants to desire to give a chance, a 7 days chance. or
No,
3
no.
days.
You have
Or
not
2
filed
days
any
also.
objection since you have entered appearance. I have looked into the record.
Yes, I have paid. I
Huh.
received.
You have entered appearance as of
10/8/2020.
uh, notice had been issued. 2019-2021. 4 years. Heard.
By the 4
Miss
years.
Miss A. Begum.
My oral objection be recorded.
And Miss A. Begum, Learned Counsel for Learned Additional Public Prosecutor for the respondent state. And Mr. J. I. Borvia.
But one thing, my lord,
Uh,
before dictating.
For the respond number 1 to 6. First of the instant application under section 5 of the Limitation Act 1963 for is preferred for seeking condonation of delay of 86 days in filing the petition in preparing the accompanying criminal appeal under section 378 within bracket 3
Yes.
of the Code of Criminal Procedure
Remember this is-
1973. Full stop.
It took 1 hour, miss please to.
We have gone
It took the leave application.
through.
Condemnation दिया नहीं.
The contents, statements, and amendments made in this instant application, including a more particular comma. paragraph 4 and 5, 4, 5, 6 and 7 thereof.
So borrow this thing.
Those two. Notices were issued.
My lord, in the notice, I have received different notice, my lord. Lordship, can you have a look? They supplied to us only leave application, not the IA of the condemnation. Ito kung ano? Yes. Bawa, hubo time na balik. That was supplied to us. It seems to be a leave application for appeal.
এইটো ক'ত ক'লে আপোনালোকে? আৰু 12 আছে নেকি কিবা? আৰু কিবা এখন আছে নেকি? চাওকচোন 18 CLP. মাৰি পেলাই থৈ দিব নিজে কৰে। চব বেলেগৰ পটত। শুধু ওপৰে ওপৰে মাৰি পেলাই বৰ্ডাৰ মাৰি থৈ দিয়ে। কোডবোৰে মনে হেৰি কৰে নে?
To court.
Leave granted.
I supplied this copy.
Leave granted.
But delay petition was not served upon me, my lord. Lordship will see it from the record. That I, leave may be granted. By some, yes. Leave would be there.
Technical consideration to get together.
Lordship will see the,
In along with the instant application for condonation of delay, comma, state had filed a petition seeking leave to appeal against the judgment and order of acquittal dated 14/3/2012 passed by the Learned Sessions Court Nalbari in Sessions Case number 18 of 2007. Post op. By the judgment and order dated 14/3/2012, comma, the accused persons, comma, the respondent number 1 to 6 hearing, comma, were acquitted from the charges under 364 IPC and section 302 IPC, read with section 34 IPC, framed against them. Full stop. Para. By an order dated 8/5/2017, comma, this court granted leave to the state to appeal against the judgment and order dated 14/3/2012. Date to Colotin 8/5/2017. Full stop. The registry was directed to register the criminal appeal and release the same expeditiously. Full stop. Para. In the accompanying criminal appeal, which has been registered as criminal appeal number 184 of 2017, comma, after issuance of notice, comma, the respondent number 1 to 6 entered appearance in the year 2021.
Paper book was directed to paper. Three eleven.
Having regard to the statements made in paragraph 4 to 7 of the instant application, we are of the considered view that the state has been able to explain the period of delay of 86 days by showing sufficient cause for stop. Though the learned counsel for the respondent number 1 to 6 has raised an oral objection, no written, it is noticed that no written objection has been preferred by the respondents to the instant application, despite their appearance in the accompanying appeal. Criminal appeal as far back as in the year 2021. Full stop. For consideration of any issue of delay, it is the interest of justice which prevails over technical considerations. Full stop. We have offered a view that interests of justice will be better subserved if the accompanying appeal, criminal appeal, is hard on merits by condoning the period of delay of 86 days. Full stop. Accordingly, in the instant, it will interlocutor application stands allowed. As the accompanying criminal appeal has already been registered and the paper book is made ready, no further order is called for. Stop. এইটো আপুনি খালি এইটো 4তে দিব 4ত separate কৰি দিব item 222. Heard Mr. G.I. Borbhia, learned counsel for the appellant, and Miss A. Begum, learned edition. Oh, উপৰখিনি চেগ্ৰিগেট নালাগে কৰিব উপৰখিনি চেঞ্জ কৰি দিব এই হাৰ্ড চেঞ্জ কৰি দিব G.I. Borbhia, learned counsel for the appellant, and Ms. K. Begum, learned additional public prosecutor for the respond number 1 state, and Mr. G. Alom, learned counsel for the respond number 11. What about the others?
Yes, my lord, Lojima court has given report, my lord, they did not turn up. Lordship will see the Lojima court's order.
But here in the call list,
Only
many
11
persons' names are shown.
11 appeared.
No, 2 to 11 also.
11 appeared.
Filing Wakalatnama,
Pune appeared.
the another set of counsel. As per the office note dated 29/5/2017, another set of counsel
E. Ahmed
has
And I-
entered appearance
appeared.
on behalf of the respondent number 2 to 11 by filing Wakalatnama. Full stop. However, none has appeared today for the respondent number 2 to 10 on call. Though the names of the learned counsels are reflected in the call list. Full stop. Para. On 3/11/2021, this appeal is listed together with criminal appeal number 222, 2006, and the instance of Mr. Borbunian Learned Counsel for the appellants. Full stop. Para. On perusal of the case papers, it transpires that the instant criminal appeal is preferred against the judgment and order dated 30/3/2016 passed by the learned session judge. In criminal appeal number 3/2009, whereby the accused persons accused as appellants were acquitted from the charges under section 143, 447, and 427 of the Indian Penal Code. Post of the criminal appeal was preferred. Criminal appeal number 3 of 2009 was preferred against the judgment. An order dated 22/12/2008 passed by the Court of Learned Judicial Magistrate First Class Nalbari in ZR case number 342 of 2006, whereby the accused appellants, whereby the accused persons were convicted for the offenses under section 143, 447, and section 427. IPC. Apart from acquitting them from the charge under section 302. Nalai.
302 is not.
Postal. In view of the offenses involved, we find that the criminal appeal, this criminal appeal is to be listed before, is to be adjudicated before the single bench. So therefore, the registry to detach this criminal appeal from criminal appeal number 184 of 2017, and thereafter to list the same before the learned senior bench. So much confusion.
My lord.
You.
Number 5.
What is? The IA has come before the so novel court for allowing suspension of sentence and to go and bail. But in 302 fees, my lord. But here in this case, I'll carry. Like it.
Fine.
Itu among the
What is your judgment?
my lord, judgment starts from
Yes.
my lord. It starts from page 12, my lord. In I.
That's it. There is a problem. It has provided me a different file.
No paperwork is ready.
Yes, my lord, but
Oh.
don't know how.
My lord, for their fault, my lord, we cannot suffer, my lord. If they want, we can.
Ah, everybody makes fault. See the previous case. 2 appeals.
This is the way we are going.
Yes.
2R is human.
But to make Himalayan blunder is something different, my lord.
Huh?
To make a Himalayan blunder is something different, my lord.
Ah, it was blunder in the previous
Previous case.
cases. Everybody.
Yes, sir. Your lordship has now digged up everything and brought it on record in
Then I
clear
saw
terms.
one order by the paper book. So directed to make paper book also.
No, are you ready or not ready? That is a simple thing.
That's why.
Not
it
ready.
takes tomorrow, but
Not tomorrow. Tomorrow I will be sitting in another division bench. I don't know.
And also.
Up to what time it will continue.
But where is the.
Friday,
guarantee
Friday.
again you will come prepared?
Mr. Kamar, Friday then? Friday?
Just a moment, my lord, because I have some food. Friday will be, my lord, 23. Can it be thereafter, my lord?
And it will go roll over to Monday.
23, Monday, my lord. Monday, okay. my lord. Yeah, आगे तो दिन में बोल-
Okay, help me.
Had he said earlier, I could have believed, my lord. That is the main issue. I took
Then
time.
Okay,
took
okay.
5 minutes.
Anyway, my lord, there are
Monday.
other 2 items, my lord. One is date sentence.
That may not be possible
Yeah,
today.
I have come to know, my lord, but my presence is required, my lord. Then
Okay, we'll do
another
that.
matter, my
And
lord.
Mr. J. Kamar, learned senior counsel, listed by Mr. P. Devchari, full stop. On on the request of Mr. R. Kosik, learned additional public prosecutor for the respondent state, lays the case on Monday. Okay,
19, in 19, this is.
item 19 and 20.
This is date reference, item 19. is it?
Okay, Z. Kamar, learned senior counsel and amicus curiae for in the date reference. And Ms. V. Sharma, learned amicus curiae for the appellant in 19. And Mr. R. Kosik, learned additional public prosecutor for the respondent state. So then Mr. Kamar, it will go after vacation. As sought for and agreed to by the line for the parties, list the cases immediately. On a date, immediately after the ensuing subsequent.
There's another item, item 14, my lord. In that case, some mention is to be made because one time due, my lord. Juvenile.
Will not today, will pass on
Then
Friday.
it is on 23rd.
We have heard Mr. I think,
Yeah, my lord. All
something regarding juvenility.
On last order, the directed to file an objection because there was one IA pending 89 petition. Plus, Lordship directed the district to provide me a copy of that report. Accordingly, I have filed a motion.
Okay. This is juvenility, right?
Yes.
Yes, ma'am. There's a report, my lord, everything,
Let it be, we have deliberated upon the issue.
yes, yes, to an extent, ma'am.
Okay. Friday.
But let it be on the same date, 20.
File operating record.
You will
Okay.
also find out
14 to
on your file.
17.
Well,
আগৰ order লগত add কৰি দিব Z Kamar senior
Hmm.
counsel, huh?
14 root cut also, yes.
Which assisted by Mr. N. Ahmed Puri.
14
আগৰ
to
কেইটাৰ
17.
লগত, huh?
14
14
to
to 17.
Yes.
But in one case,
That is specifically item number 14. There are one, by the 389 pending. So your lordship.
there was another issue I indicated that after 30
5
years,
years.
there is no value of ossification test. Law says,
One
In the-
person
in
is
our-
aged
and the-
84 and the other is aged 16. What will which maximum?
I think enamel height, লিখি দিব Z Kamar and senior counsel estate by enamel, huh? আগৰ order. And so for two better parties, Mr. Kosik Land, the additional public prosecutor has submitted that an objection on behalf of the state has already been filed. Close to record, it is on record. The office to trace out the objection filed on behalf of the state to tag it with the case records. So release the cases on next same Monday.
Same 20,
Monday.
23.
33.
এইকেইটা হ'লে এইকেইটা হ'লে আঠটা দেখোন বেলত আছে য'ত চাৰিটামান জুবিনাই হ'ব নাই
Well, in this
Right.
case, just for one moment, can I address the court, my lord? I was thinking, my lord, that there is a person aged 84 years accused. When the juvenile, because of which young age can be released, why not a super senior citizen, my lord? They being termed as garretic persons.
I will look into it.
My lord, that.
Sure, you represent that one.
I,
Goldman.
I thought I'll make a submission if the law to permit me. Why even if the young can be released, why the super he cannot be released?
Yes, sure.
There's a department also nowadays in GMC, malacaratic persons. World. Okay. Much okay.
We thought that we'll hear the appeals itself. Piecemeal basis instead of
Facts of
piecemeal
the
basis.
appeal is very pathetic.
Otherwise, it is almost 10 years.
Okay. Monday, we'll consider the bill.
Please, your lordship.
Item 6, yes.
Please, your lordship. We have taken step on the opposite party number 2, lordship. But he was died.
This is what? 323?
303.
302.
Lordship.
Okay, 302. I objection filed. Yes. Now,
Lordship, I is for bail, lordship. Lordship, the prosecution case is based on two eyewitness, lordship PW 7 and PW 8. They are injured person and considered as an eyewitness and also a daughter of the deceased person. As lordship, in this regard, they are related witness. Therefore, lordship, they are interested witness considered.
related may not be interested,
Yes, lordship,
but
they are,
they are also injured.
yes, lordship.
Injured is kept, injured witness is kept at a higher pedestal. And related does not always mean interested. Whether they had any prior NPT? No. Huh? Where is the judgment?
Lordship judgment in page number 41 in appeal. See. Page number
Yes, number
41.
41. Five persons
Yes, Lordship
accused.
accused. Initially,
One was convicted.
yes, Lordship. Case number 2 was
So one has been convicted. His name is Pokrul.
Pokrul, yes, Lordship.
Okay. Seven and eight. Related. Your Honor. Doctor was examined as
11, Lordship.
PW
11.
11. Where it is discussed. PW9. 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 Doctor evidence is not discussed. Okay. পিছপানে করছে। So diseased sustained head injuries. It was inflicted by A2, P7, P8 were injured witness. They were examined by the doctor on the same day. Their testimony were consistent so far as assault on the diseased as well as on them. As on date, this is not a case for 389. Not interested witnesses. One was interested witness. It looks like one was interested witness. Who was interested witness? Let me find out that.
Lordship, PW.
PW something, who had some litigation earlier.
Yes, Lordship, PW3,
Ah,
Lordship.
he
Yes.
was interested
And
witness.
PW8 also live in separate place, Lordship.
Who were the injured? PW7 and 8.
7 and 8, both are injured, yes.
And both are daughters of the deceased,
This is.
related, but also injured.
Well, Lordship, moreover, postmortem report, the name of the deceased was shown as Saraya Khatun, wife of Muna Pali, but actual name is Sahera Khatun, wife of Abdul Muna.
Those are not to be considered at this stage. So, accused was convicted under 302 and 323.
Yes, Lordship.
Hello, daughter. Inside the house, campus. So their presence was natural. Their presence was natural. Their being daughters in the compound of the deceased house. So their presence was also natural, and moreover, they sustained injuries. They were examined by the doctor on the same day, and injuries were found. Then there was head injury on the deceased, and it has been corroborated by medical evidence, and their testimony is consistent. Not a case for at this stage. Hard miss.
TMC, Lordship, till the disposal of this appeal, Lordship kindly allow.
No, till the disposal, they will be behind bar. Other way around. He. At this stage, where is, if it is a case of a delayed hearing, that is a different matter altogether. But it is a case of 2024 appeal. Heard. Miss K. M. Soikia, learned counsel for the applicant and Miss S. H. Bora, learned additional public proceeding for the opposite party that's respondent state of Assam. Post of the instant application under section C89, Code of Criminal Procedure 1973, within bracket, presently, section 430, Parvati on Agoric, Puraka Honita 2022. Is preferred seeking suspension of execution of sentence passed against the appellant, and for his release on bail. Post of para. The applicant as the appellant has preferred the accompanying criminal appeal, criminal appeal number 35 of 2024 against a judgment and order dated 10/11/2023 passed by the Court of Learned Sessions Judge Nagaon in sessions within bracket T-1, case number 278 within bracket capital N of 2022. Post of. In the
2012.
trial of 2012. In the trial of sessions within bracket T-1, case number 278. In the same trial, in the trial of session. 5 accused persons face the trial for charges framed under section 325 and section 302, read with section 34 of the Indian Penal Code. On conclusion of the trial, the trial court acquitted 4 of the 5 accused persons from the charges, from the aforesaid charges, 7 except the appellant. Full stop. The appellant has been found guilty for the offences under section 302 IPC and section 323 IPC. So for the offence under section 302, IPC, the appellant has been sentenced to undergo a rigorous imprisonment for life and to pay a fine of rupees 10,000, with default stipulation. For the offence under section 323 IPC, he has been sentenced to undergo rigorous imprisonment for 3 months and to pay a fine of rupees 2,000, with default stipulation. Para. Having regard to the submissions made by the Land Council for the parties, we have gone through the evidence stroke materials on record, including the testimony of the prosecution witnesses, including the testimony of the doctor, medical officers who performed the autopsy on the deceased and examined the injured witnesses, PW7 and PW8 on the date of the incident. The incident occurred on 28/8/2011 in the premises within the compound, within the house compound, within the compound of the dwelling house of the deceased, Sahera Atun. The two daughters of the deceased Sahara Khatun were examined as PW7 and PW8 postal. From the testimony of the autopsy doctor, PW10, and the postmortem examination report within bracket EXT4, comma, it can be noticed that the disease sustained head injuries on her head. Sustained a number of injuries on her person, including one including one on the scalp. On the head resulting united fracture over right frontal parietal region. Most of all the injuries sustained by the disease were antemortem in nature and were caused by blunt force impact. Post op. PW7 and PW8, who were the daughters of the disease, testified as regards the assault implicating the appellant. Post op. The PW7 and PW8 also sustained injuries on their persons, and the medical officers who examined them on the date of the incident itself had found injuries on their person. So therefore, the prosecution witnesses PW7 and PW8 would fall in the category of injured witnesses. Though a contention has been advanced to the effect that the PW7 and PW8, apart from being related witnesses, were also interested witnesses. In view of such contention, would require a detailed appreciation of the evidence on record, and the same cannot be gone into while considering an application under section 389 CRPC. Post op. The law is settled that the testimony of an injured witness is to be considered the higher pedestal. Post op. And a witness can go, even if a related witness, may not be an interested witness. So, standard prior to the having a regard to, or after having gone through the evidence stroke materials on record, including the testimony of the prosecution witnesses, including the injured witnesses and the medical evidence. For the purpose of consideration of the instant application preferred under section 389 CRPC, we are of the considered view that the applicant definitely has not been able to make out a case for suspension of execution of the sentence passed against him and for his release on bail. At this stage. Those two. Consequently, the instant application is found bereft of any merits. And accordingly, the same stands dismissed. However, way of observation shall only for the purpose of considering last paragraph accompanying email. Art came so yeah, then also for the appellant. And Miss S.H. Oral and additional public prosecutor for the respondent state. The case records of sessions T case number 278 and 2012 are received. Post of registry to start preparation of the paper book. Post of release the case after 4 weeks for a report as regards readiness of the paper book. Report from jail. Ramsam appointed for a Simple. The learned amicus curiae. But appellant is found absent today on call. Why? Plus two. Mr. Sage Bora, learned additional public prosecutor for the respondent state, is in attendance. As the trial court, as the case records from the trial court are received from the registry to prepare the paper book, first of release the case after 4 weeks for a report as regards readiness of the paper.
Number 8.
His Lordship, I am appearing on behalf of my senior, Mr. M. Sharma. He has been appointed as an amicus curiae in
Your name, please.
S. Chauhan.
H. Chauhan. Chauhan and paying for Mr. M. Sharma and I make a script for that. Mr. Sage Bora and additional prosecutor for the respondent state. As the case records of. From the trial court, I received from our office to prepare, the office to prepare the paper. This is the case after 4 weeks for a report as regards readiness of the paper.
Item 9.
With the Lordship. Lordship, matter may be passed over for the Lordship. Senior counsel P.J. Swikia will appear in this matter, Lordship.
On the request of Mr.
M. Rahman.
M. Rahman, learned counsel for the applicant. The case stands passed over for the day. Mr. R. R. Kosik, learned additional public prosecutor. A sound. For the respondent state has submitted that. The objection on behalf of the state has already been filed.
Since I got here, we have to ask.
I will fight a privacy case, whether it is there or not. Go to the LCR.
Obliged.
Item 10.
No, 28/5, this, with more than 15 days, they got my. Anyway, I left your Lordship on about 1
Okay,
day.
on Friday then.
Friday, madam.
HR Chaudhary, Learned Senior Counsel listed by Mr. A. M. Ahmed, Learned Counsel for the applicant appellant, A. Begum. And additional public prosecutor for the opposite party, that's respondent number 1. And Mr. T. Chakravarti, Learned Counsel for the respondent number 2, that's informed. Heard. Mr. Chakravarti, Learned Counsel for the respondent number 2, that's informant has submitted that the objection on behalf of the respondent number 2, that's informant, is going to be filed during the course of the day. Full stop. List the case as
I mean,
agreed
can it
to
be
by
on
the Learned Counsel for
for
the
Thursday,
case.
my lord?
Huh?
Friday, we have some, Your Lordship, can it be on Thursday, my lord?
Huh? Not Thursday. No. This, those only criminal appeals will hear.
Okay, no, all right, it's Friday, madam.
Friday.
I'm okay. Item 11.
Because time will be eaten up.
But
If we hear this, it takes lot of time, always. And there is no time left for criminal appeal.
So, anyway, my lord, that's.
And Thursday we have fixed another matter, I think yours matter, perhaps, or somebody else.
My lord, the office now there is 19/5/2025.
90 million.
Service someone responded now, but two, there is the improvement has been completed.
Who is the legal aid counsel?
My lord, KP Pathak has been appointed as legal aid counsel. He's midst of hearing another court, my lord, and appearing on behalf of it.
We are in a division bench and amicus is not appearing. We
Yes,
have been
madam.
found, we have been finding it.
Yes, my in that case, my
We have been
lordship may pass
finding it.
over for the timing.
We'll go on changing the amicus.
In that case, lordship may pass over for the timing, I will.
This is not the not an issue which is to be appreciated.
Apologies, my lord.
Hard,
Beat us, my lord.
PDAS, learned counsel. Appearing for Mr. KV Pathak, learned legal aid counsel for the applicant. And Mr. R.R. Kosik, learned additional public prosecutor for the opposite party number 1, State of Assam. Post of. Yes, 106 days. As per Law Jima order dated 19/5/2025 of the Law Jima Court, the service of notice upon the respond number 2, there's informed is complete. Post of. The instant application under section 5 of the limitation in 1963 is preferred, seeking conversion of delay of 106 days in preferring the accompanying criminal appeal against the judgment and order dated 24/7/2024 passed by the Court of Learned Edition, Session Judge cum Special Judge within bracket POCSO against in POCSO case number 11 of 2021 posted by the judgment and order dated 24/7/2024. The applicant has been convicted for the offenses under section 376 within bracket 3, Indian Penal Code and section 6, POCSO Act in view of section 42, POCSO Act, the applicant has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 10,000 under section in default of payment of fine, to undergo rigorous imprisonment for another 3 months under section 376 within bracket 3 IPC. He has also been convicted under section 450 IPC and has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 5,000 with default stipulation. The Special Court has ordered that the sentence, both the sentences are to run concurrently, post of para. We have gone through the statements and environments made in this application, comma, more particularly, comma, paragraph 4 and 5 thereof also. After the judgment in order dated 24/7/2024, comma, the applicant sought legal assistance on 30/7/2024 to prefer an appeal. Post of it was on 12/8/2024, comma, the secretary, District Legal Services Authority, Morigaon, forwarded the matter to the High Court, Guwahati High Court Legal Services Committee. And the legal aid council, and legal aid council came to be appointed on 28/2024. Also, because of the incorrect nomenclature in preferring the appeal as criminal appeal instead of criminal appeal within Beacon Jail initially, comma, the appeal had to be withdrawn and a fresh appeal has to be preferred. Full stop. Having regard to the statements and environments made in this application, explaining the period of delay of 106 days, we have to consider view that the applicant has been able to explain the period of delay showing sufficient cause. Full stop. Moreover, comma, since the applicant has been sentenced to undergo rigorous imprisonment for 20 years, comma, we are also of the view that interest of justice will be better served if the accompanying criminal appeal is heard on merits after condoning the period of delay. Full stop. Since the respondent number 2, opposite party number 2, that's informant, has not appeared despite service of notice, comma, the respondent so cease now here. Full stop. In view of the above, comma, the instant application seeking condonation of delay of 106 days in preferring the connected accompanying criminal appeal is allowed. Full stop. The interest of target. The interest of the respondent number 2, opposite party number 2, that's informant. No, sorry, when it is further observed that the accompanying criminal appeal will be hard on merits after ensuring service of notice upon the opposite party number 2, that's informant. Obviously, in view of the above, the instant application seeking condonation of delay of 106 days in preparing the accompanying criminal appeal is allowed. The registry to register accompanying criminal appeal and thereafter, comma, to list the same for admission.
Obliged.
Number 12.
But I am not, you have mentioned for yesterday. Interest নাই নাকি? কিন্তু এইবোৰ প্ৰিন্টাৰ এইবোৰ চাই দিব পাৰি। এইবোৰ ডিটেইলতে পাছ কৰিব আৰু। কিবা টাইপিং এৰৰ। টাইপিং এৰৰ আৰু টাইপিং এৰৰটো এখন বেঞ্চ আছেই। এইখন বেঞ্চ পেজ 15 এইখন পেজ 15 চাওক। পেজ 15ত এইখন বেঞ্চে জাজমেণ্ট দিছে। এইখন বেঞ্চে জাজমেণ্ট দিছে হয়নে? সেইটো কথা। There is no representation on behalf of the applicant to the on-call. His stance passed over for the day.
Item number 13.
May I please your lordship?
Third, Mr.
Here, Rahman.
A. Rahman. Land transport applicant. Posted. There is an application under section 5 of the Limitation Act 1963 seeking continuation of delay in preparing the accompanying appeal. So, appeal to some. Appeal to file. Under section 9 of the para lo hace de under section 19(1). 19 we back at 1 day. 19 of the Family Court Act 1984 against the judgment. 2 days questioning. 2 days questioning. Seeking conversion delay of 2 days in preparing the accompanying appeal under section 19 of the Family Court Act against the judgment and decree dated 23/12/2024 passed by the learned Principal Justice Family Court Class 1, Kamrup Metro and Guwahati in FC within bracket civil case number 393/2017 issued notice returnable in courts as the applicant shall take steps for service of notice upon the sole respondent by registered post within 3 working days from that is the case after courts.
Supplementary list for orders, item 21.
The last 28/5, you are also directed to submit the translated copies of FIR 164 and other things. We have accordingly we have filed it and we have supplied the copy to the Learned Council mail. On 12th, we have given it.
Lordship, Miss Neha Lordship, today informed for some medical emergency, Lordship. She is out of station, Lordship. So, Lordship, all the organs seen by my Lordship.
Your other case is Friday.
Madam?
Your other case is Friday, on Friday.
Friday.
Friday. The B here is not available.
We have submitted compilation.
Heard Mr. H.R.A. Chowdhury, learned senior counsel assisted by Mr. I. Chowdhury, learned Ms. A. Begum, learned additional public prosecutor. For the opposite party, does respondent 1, State of Assam, and Mr. J. U. Ahmed, A. Hussain, Land counsel for the opposite party, that's too informed, first of all. Mr. I. Chaudhary, land counsel for the applicant has placed translate copies of the FIR, statement recorded under section 164 CRPC, and the type copies of the medical reports, etc. And the same are kept with the case record. First of Ms. Begum, Learned Additional Public Prosecutor, has submitted that Ms. Bhuiyan, B. Bhuiyan, Serial Concern and Additional Public Prosecutor, who is to appear in this case, has some medical emergency and has thus sought for listing of the case on Friday. So,
They
Monday.
will not be available on Friday.
Monday. then. If it is Bombay, then
Mumbai is shorter than Rockville, madam. Silchar. Mumbai is shorter than Koimbatore.
but hospital treatment. Appointment of doctor is more difficult. Okay.
Compilation, everything, even that case, madam, medical was done prior to the FIR. madam.
We will look into it. We'll not exercise our mind.
Madam, what you also record, we have supplied the copies to them, madam. That may be kind of record. Yes, yes.
Which copies
As per your lordship
to
direction.
the land additional public prosecutor. That's in view of the ground cited on behalf of the land additional public prosecutor is the case on Monday.
Obliged.
Monday, I'll call it. And you look here, most of that. It is Kamarnigi. Mr. Surya, on Wednesday. Z Kamar has taken Monday dates
Next
for
week,
3-4 cases.
next week, then, day
Wednesday,
after
okay,
tomorrow.
next Wednesday. Which Bhuiyan is not available,
Next week, your lordship available, next week.
hopefully. Hopefully.
Wednesday, no?
25.
25.
Item 22.
Wait, please also. Last time I've been provided with these medical papers.
Hmm.
The lordship takes up, there's a report dated 23/8/24. Medical report of Puniram Nath Hospital.
Firstly, Mr. Prasad ji,
Hello.
this otherwise, there is a matter which is to be dealt with by the district mental,
Understand, ma'am? Nothing was happening, that's why we came before your lordship again.
because otherwise, if we go on this, dealing with these issues,
I understand, my lord, because
it
there's
is
earlier
the,
an order.
it is the jurisdiction of the district medical review board to take a decision on the basis of the report, is it not?
Rightly. I'm.
When the criminal division bands dealing with the appeals should be dealing with this kind of matters.
Because your lordship will remind, recollect.
I have passed the order.
Ah.
Yes, I have passed the order. I have disposed of the matter.
Yeah, after that, nothing was happening, so we had to come.
No,
Board was set up.
question is whether we should deal with this matter. Whether he is the person who is to be presented before the medical board. Thereafter, a committee has been constituted, a statutory committee has been constituted, who has been provided with the power, authority and jurisdiction to deal with the issue in appropriate manner. Is it not? So I do hold it.
The lordship takes up IA page 19. Lordship's order starts at page 10. Page 10, the order starts, relevant portion, my lord, at page 16. Page 15, my lord.
It was 340, not excellent.
341 or 25, I.
One minute, these are huge.
Page 15 is the
1
relevant.
minute.
Right.
Why do I maintain variance services with persons? Mental health care also. Para 16 and 17, it was made clear that jurisdictional mental health review board will give consideration to the case of the applicant. Then what did the mental health review board? Huh?
Based on the current medical examination and available documents, the patient is provisionally diagnosed as part so and so. Paranoid schizophrenia is remission on medication with mild cognitive disorder and hypertension, diabetic mellitus, and hyper.
Yes, this particular report of the medical board is to be placed before the jurisdictional mental health review board. And it has to consider, it has been given the power and jurisdiction to deal with the issue.
No, my lord, this has been sent to the jurisdictional district judge because 31st August, the papers that my learned friend had provided, 31st August 24. From superintendent to honorable district session judge, come mental health review board. Kamrup. 31st August, my lord, 31st August 24. With reference to the subject cited above, I have the honor to forward here with medical report of in original respect of so and so submitted by Superintendent Guwahati Medical College. And this was sent.
This was sent to district jail.
This district judge,
No, district superintendent of district jail.
Superintendent sent from
superintendent.
superintendent.
Huh?
To honorable district.
Lordship, this document 31st August. I think it's in the bunch of papers that my learned friend gave last time.
The last thing.
And there's a flag X in pink. Second last page of that.
Second one. But they didn't send the report to the superintendent, district judge lordship, as there was no order. Send the report, was not sent to superintendent lordship.
What papers have been given to me, this report was sent to the.
Because the previous order, Ms.
Right.
Begum, a copy of the order was also furnished to you to take necessary steps from your end, which means also and includes the mental health review board also. Because of that, because we have to indicate each and everything in the order.
So registry lordship.
No, I have said that from thought to take necessary last line, para 19. What did you do? Because
That they have sent.
you should have sent it to the mental health review board also. Because we have observed something on mental health review board also.
But since nothing was happening. we
Because
filed the petition.
before you say that this to up to peon, if we make it clear in the order. Because paragraph 16 and 17, it includes also the mental health review board. Right? Observation was also there for 16, in 16. See?
What should I-
The observation made by the so and so to place the case of the applicant appellant before the jurisdictional mental health review board at the earliest for consideration of the case of the applicant appellant under section 103 so and so within 15 days from today, along with all the relevant records including the medical reports of the so and so. So these are it is expected. We thought that I think this necessary steps would be taken.
There is one report lordship that
But despite orders,
lordship is paid
nobody is
the
giving any heed.
second page lordship. Right? Second page lordship. Point number 5 lordship, the district jail Morigaon. my letter so and so submitted the medical report. Honorable district judges help we look for that. They have sent it. Then Lordship, in the next paragraph, in this regard, I would like to inform before the honorable court that 5 number of prisoner managed to escape from the district jail on the night of so and so, and accordingly both superintendent and jailer of the district Goregaon, Assam was transferred from the
No,
establishment.
we are concerned with mental health review board.
They have
But jail has done their part, as per
Huh.
what I have understood.
Paragraph 5.
Paragraph 5. Jail has submitted it to the district judge, Kamrup. If your lordship takes up my IA, page 19.
We'll transmit this,
My lord, but that will suffice, I think. Because in January this year also.
a copy of the previous order
My lord,
and
reports.
report already it has been given by the district jail Morigaon by letter number so and so. So mental review health board should take up the case of the applicant appellant in terms of the mental health care act.
So we have filed a representation on 21st of January before the mental health review board to look into the matter, but nothing has happened. That's why we have to come before the lordship. It is annexure 3, page 19. I have the next.
Heard Mr. D.K. Borasaji, learned counsel for the applicant appellant, and Miss A. Begum, learned additional public prosecutor, Assam for the opposite party, this respondent goes to para. This court had passed an order on 19/5/2025 on this application to stop the relevant excerpts from the said order are extracted here in below, paragraph 2 to paragraph 8. Full stop. Para, it is pertinent to mention that the applicant had earlier moved an application on interlocutory had earlier moved an interlocutory application, I criminal 168 of 2024. Full stop. As the case of the applicant had been recapitulated in the order dated 25/6/2024, whereby IA criminal 164/2024 was disposed of, it is have to extract the relevant parts from the said order dated 25/6/2024, paragraph 2 to 19. Close to para. When the instant present application was moved, learned additional public prosecutor was asked to obtain the superintendent district jail Morigaon was directed to apprise this court Why the direction made in the order dated 25/6/2024 was not carried out in time, as noted in the order dated 19/5/2025. Full stop, para. From the office letter number DGM 18/2025. Stroke 1080 dated 2/6/2025 of the Superintendent District Jail, Morigam, addressed to the learned additional public prosecutor, it transpires that the authorities in the district jail, Assam, Morigam, Assam, submitted the medical reports of the applicant before the Biden office letter forwarded the medical report of the applicant. Biden office letter number paragraph 5 of DGM 18/2024 stroke dated 31/8/2024 to the chairman, Mental Health Review Board, Kamrup Metro at Guwahati, and the said and the receipt of the said office letter along with the medical report was acknowledged on 2/9/2024. Full stop. Para. As already noted above in the order dated 25/6/2024, Supra, extracted above, it is the jurisdictional mental health review board which should give expeditious consideration to the case of the applicant under the provisions of the Mental Health Care Act 2017. Postal. As no order passed by the Jurisdictional Mental Health Review Board has been placed before this court, registry to transmit a copy of this order to the chairman, Mental Health Review Board, Kamrup Metro, Guwahati, for compliance of the direction made in the order dated 25/6/2024 passed in I Criminal 168 stroke 2024. First of list the case after one for a report from the Mental Health Review Board, Kamrup Metro, Guwahati. That can be done only.
Yes, sir, that is only. I need.
Because they can take evidence, everything they
yes,
can do.
Yes. Nothing was happening, so we had to file this IA.
Alternate method for hearing, item number 23. On last occasion, the Lordship has gone through the entire evidence.
Yes.
I found something little, but there is something Lordship, because in if I go to Lordship PW, let me first go to PW 20 Lordship. PW 20, page number 56.
PW 20.
56, PW 20
Mr. Dhar, you take your seat.
Lordship. Page number 56, last three lines. Last three. I came to learn from Aarti when she stated before me that she kept Dalima, Datta holding and accused Binu Mohanta inflicted. She didn't say the name of the other. Only she have said that Binu inflicted them. And Lordship.
Suppose Mr. X came to know from Mr. Y that this had been done,
He's not at all interested with this, that he will. say
right? Mr. X came to know from Y
one.
that this had happened, right? Here is a
I
case,
came to
Mr. X came to know from the accused.
accuse.
If Mr. X deposed
Lordship.
to the effect that I came to know from Mr. Y, what would be the nature of evidence? What would be the nature of evidence? If Mr. Y came to know, Mr. X came to know from Y that Y had told me this, then what would be the nature of evidence?
Let's say.
Huh?
Because
It is hearsay.
I came to learn from Aarti. Lord.
Huh?
Aarti is the.
I said, Mr. X came to know from Mr. Y that Y told me this, right? Y is an impartial person. Still then it will be in the nature of hearsay. Now here is more. Mr. X came to know from accused that the accused told me. What will be that? Evidence. What is termed as evidence? Section 3. Does it fall? Fact. Fact means and includes. Any fact, state of things, or relation of things capable of being perceived by the senses. Perceived by the senses of that person, not by senses of other person. Any mental condition of which any person is conscious. Illustration. And what is direct evidence? 56. Okay, not 56. Oh, proof actually need not be 56. G. 9. And 60. 60. He heard it. It is there.
Lordship, I
But,
came to know.
but any inculpatory statement it can be accepted under section 30. But the case is that the case is not tried together. ROT is not tried together.
That's one. One more thing in the IO lordship. That is page number where lordship. I'm getting little
Hmm.
page 75 lordship. Page 75. First paragraph, okay. Here it is material exhibit 5.
Material exhibit 5.
5 is a colorless sporting marked as MR number 508.
Hmm.
But in serial list, it is different logic. Because this 508 give a positive test of human being. In page number 74,
74.
74, last paragraph logic, last, between the line one. 12th line logic from down.
Let us see MR. Let us see the MR first. MR 05.
MR, that is logic.
Exhibit 5.
That one is in page number, 158.
158.
158 it is written as 9,
158.
page 158.
One light blue half sporting Genji
Logic.
without collar from Binoy.
That is.
Uh-huh.
But the question in chief lordship, you have mentioned as MR number, 05. that is
158.
150. In here it is, MR number 9. MR number 9,
158 is MR number exhibit 10.
exhibit 8, MR number,
MR number, who is that MR number? 9. Original sound.
there's the,
Oh, original 9.
that is the problem. Lord. So.
But
Question, chief,
uh,
is on page 75. Material exhibit 5 is the colorless. First, third line, first paragraph.
before.
Positive case for women law. Page number 75, third line. Yes, colorless, MR number 508.
Negative. 2230. Come to page 174.
75, the same.
174 first.
74.
The 4, serial number 4. One light blue colored half sport Genji having stain of suspected blood. Right?
Okay.
Then turn to the next page. Serial result of examination. 2301, it will be D. It is negative test for presence of stain?
That is, here
Hmm.
Lordship, exhibit page
Uh,
174.
mm,
Here it is written as exhibit number D, MR number 9 of 08.
Hmm.
But again in chief lordship, we have said it is 5 of
whatever, the Genji was seized by,
5 of 08.
Genji was sent,
Then, and
this FSL expert
FSL expert,
marked it as 02301D.
page number 74. Page only 74, where they have said that the said report gave positive result for human blood.
Oh, 74.
Page number 74,
Huh,
down from down 12 line,
74 from,
when the IO gave his deposition. After FSL Guwahati in respect to the sample blood, the said report gave positive test, positive result for human blood in respect of blood stain found in MR number 4708/4/08 and MR number 5/08. But that we cannot now verify, tell you which the original record is not available.
I'll come to 174.
174.
Please come to 174.
Yeah, Lord, I'm there.
47 of 08. 4 of 2008 and 5 of 2008. Man may are, but documents do not are. Whatever is written, unless it is erased by human agency.
And also, even 3 lordship. Who have been acquitted. Lordship, we got the 313 of Manya Munda, who was acquitted. That is on page number 92.
He admitted his presence.
He is admitted.
He denied.
He denied.
But question is,
At last, he told.
whether the situation for the appellant under section 106 have arisen or not.
Lordship. And moreover, one more thing that Lordship is.
I have checked 313. The other one, he admitted his presence. He denied, this man denied his presence.
Section number 6, he told that I was a mission, I was working there. But they couldn't say who entered the room, and he informed Lordship to the neighbor. Neighbor did not give the cow body. He brought the cow body from somewhere.
Neighbor?
He went to the neighbor house, knocking the lock. Then he told that Baido fell down. Then they came out. And that person did give the cowbird to mason. The mason brought from somebody else, the cowbird. Something is there, Lordship, something is there, but. due to some
Something will add
personal-
up, the chain will complete.
the chain. And Lordship, in RT also,
And most importantly, you have not preferred any appeal against the judgment of acquittal.
Lordship, rest and give up to you. But I've seen that legal discrepancy there and something. is-
Yes, if any little discrepancy, then it will go in favor of the accused. Because of the judgment of the division bench, in fact, it appears that there was no blood stain. It was this man who went to the house of Simon and the lady 9 and 16. He assisted PW9.
3% were there, right? Because the IO have also seen 6 footsteps. 3 persons were there, but if her husband Ganesh Tanti is there, assuming that he is there, then one more person is there. 3 person. 3 person was there. So six
Maybe the
footstep.
disease also.
Since Lordship, her footstep will be not so effective. Because she will not be in that state. Lordship.
We'll start if possible because Muslim sister will have to sit in single bench also. So we may have to rise. Now come to page judgment. Which are the circumstances? Firstly, for section 40, paragraph 43. This is the observation of the learned trial court. And the learned appellate court discarded it. 106, no. Then come to page 44. One circumstances, 1, 2, 3. Established. 4. This is Mania Munda. We are Mania Munda or Binu? Binu. Binu did not admit. Situation 4. Then 5. Yes, it is true. Now 6. These are the circumstances. And the learned appellate court, in case of Mania, discarded the situation 6. Presence of this appellant at the site has been established.
It is established.
No doubt about it.
The drawing room, preparing the surgeon.
Not drawing room.
Outside,
Not drawing room.
outside the surgeon, preparing the for surgeon. Outside.
Okay.
It's outside the drawing room, surgeon. Yeah, outside the drawing room.
Huh? Is criminal appeal. From jail. Under section 3 Code of Criminal Procedure 1973 Code or CRPC sort is directed against a judgment in order dated 19/5/2016 passed by the Court of Learned Session, yes, Tinsukia. In Sessions case number 46 within bracket T of 2010. First of all. 2 accused persons comma, namely, comma, 1, Roman 1, bracket, Binu Mahato, within bracket, the present accused appellant, and 2, Mania Munda, faced the trial in Sessions case number 4060 of 2010 for charges under section 448 and section 302, read with section 34 of the Indian Penal Code IPC. So stop. On conclusion of the trial, comma, the Court of Learning Session Judge Tinsukia, within bracket, the trial court, found both the accused persons guilty of the offenses under section 302, IPC, read with section 34 IPC, and also under section 448 IPC, read with section 34 IPC. Oh, no, not 302 IPC, read with section 34 IPC. The accused persons were acquitted from the charge under section 448 IPC, read with section 34 IPC. On the ground that the said charge was not proved. Full stop. For the offense under section 302 IPC, read with section 34 IPC, comma, the two accused persons, including the present appellant, accused appellant, comma, have been sentenced to undergo rigorous imprisonment for life each and to pay a fine of rupees 1,000 each, comma, in default of payment of fine, comma, to undergo rigorous imprisonment for another 6 months each. It has been ordered that the period of detention already undergone by the accused person shall be set off from the period of imprisonment in terms of section 428, CIPC. Full stop. Para. The first information report was lodged before the officer in charge Tinsukia Hodor Police Station on 9/1/2008 by one Dilip Sunwal, stating about an incident which occurred in the house of one Dalima Dotto at Bordolanagar, Tinsukia. At around 2:30 p.m. on 9/1/2008. In the FIR command, informant PW1 had inter alia mentioned that at around 2:30 p.m. on 9/1/2008, he came to learn over phone from the neighbors of Dalima Dutta, who was his elder sister, that an incident taken place in her house, then, the informant went to the house of Dalima Dutta immediately from his office. And going there, he saw a gathering of neighbors of his sister in front of the house of his sister. He saw his elder sister, Dalima Dutta, lying in a pool of blood in the veranda of her house. The informant had taken Dalima Dutta to Tinsukia Civil Hospital with the assistance of the neighbors, wherein she was given preliminary treatment. The doctors at the Tinsukia Civil Hospital, then referred her to Brahmaputra Nursing Home, Dibrugarh, for better treatment. In the meantime, he received information that Dalima Dutta had already breathed her last. The informant stated that a housemate by the name of Arati used to do cleaning works in the house of his elder sister from 6 p.m. to 8 a.m. That is, till that is before the disease used to go to the school. The informant stated that as per the versions of the neighbors, they saw the housemate in the veranda of the house of the deceased at the time of the incident, and he suspected her involvement in the incident. The FIR was received at the place of occurrence itself, that is, the house of the deceased, on 9/8/2008. And the same stood forwarded to the officer in charge by one Sosidhar Asani, an inspector of police, and the same stood forwarded to the officer in charge, Tinsukia Police Station, to register a case under proper sections of law. Sosidhar Asani had, in the meantime, started investigation into the case. PW 20 7. Started investigation in the case as its investigating officer. Is the IO? IO, within brackets. On receipt of the FIR, the same was registered as Tinsukia Police Station, case number 25 of 2008, for under section 448 and section 302 of the IPC. On 9/8/2008. Full stop. Whereas during the course of investigation, the IO suspecting that four accused persons, namely, one, Sarsit. 180. One, Aroti Tati. Two, Ganesh Tati. Three, Bina Mahato alias Binu Mahato alias Binoy. Within bracket, the present accused appellant. And four, Mania Munda. Were behind the commission of murder of Dalima Dotto, arrested them in the course of investigation, the IO recorded the statements of a number of witnesses under section 161 CRPC. Full stop. The inquest on the dead body of the deceased was conducted on conducted at Brahmaputra Diagnostic and Hospital Limited, Dibrugarh, on 10/1/2008 by an executive magistrate cum circle officer, East Dibrugarh Revenue Circle, and an inquest report within bracket EXT2 was prepared recording findings. Full stop. The executive magistrate, in order to ascertain the actual cause of death, observed that the dead body should be sent for post-mortem examination. The post-mortem examination on the dead body of the deceased was performed at the Assam Medical College and Hospital on 10/1/2008. And the autopsy doctor after performing post-mortem examination, recorded his findings in a post-mortem examination report within bracket EXT 12. Full stop. In the course of investigation, the IO made a number of seizures wide seizure list LISTS, EXT2, EXT3 to EXT8 and EXT10, EXT3 to EXT8, EXT10 and EXT13. Full stop. By the said seizure list, the following articles were seized. EXT3 column EXT4 and material kita detail. Index লিখা আছে EXT2 কোনটো পেজত আছে EXT3 কোনটো পেজত আছে আৰু এটা প্ৰবন্ধ দিব date of seizure. Seizure list EXT3 এটা date of seizure আৰু এটা article seized. The IO got the statement of one witness, Rebecca Das, recorded under section 164 CRPC on 17/1/2008 before the learned judicial magistrate Tinsukia. Full stop. A sketchmap of the place of occurrence, EXT14, was also prepared by the IO. Full stop. A number of articles seized by the aforestated seizure list were forwarded. 6 number of articles. No, sorry, the following articles. Following articles were forwarded by the IO to the Forensic Science Laboratory, Assam at Guwahati, for serological examination, page 174. Description of article আছে পিছফালে নাম্বাৰ লিখি দিব সেৰো নাম্বাৰ আছে 174. The forensic expert forwarded his opinion by a report dated 26/2/2008. Within bracket EXT 15. Full stop. After completing the investigation into the case, comma, Tinsukia Police Station case number 25 of 2008, within bracket corresponding year case number 44 of 2008, comma, the IO submitted a charge sheet under section 173 to CRPC. Right. Subject number. Twelve 41/2008 on 36/2008, finding a forensic case against all the 4 accused persons for commission of the offenses under section 448 and section 302, read with section 34 of the IPC. Post up. Para. On submission of the charge sheet, comma, the jurisdictional magistrate এটা কেতিয়া বলে আছে একটু কমিটমেন্ট ওটা হয় যদি এইটো থাকিল ইহঁত কেতিয়া কেতিয়া পলাল হ্যাঁ দুজনক কৰিছিল has been doing it. When the Court of Learned Chief Judicial Magistrate, Tinsukia, sought the appearance of the 4 charge-sheeted accused persons after submission of the charge sheet, comma, only 2 accused persons, namely Munia Munda and Binu Mahato, appeared before it on receipt of summons on 7/4/2010. Post up. The Learned Chief Judicial Magistrate, Tinsukia, complied with the formalities as per section 207 CRPC, post up, as the offense under section 302 IPC is exclusively tribal by the Court of Sessions, comma, the Learned Chief Judicial Magistrate Tinsukia committed the case records of GR case number 44 of 2008 by a commitment order dated 7/4/2010 to the Court of Sessions, Tinsukia, for trial post of. The learned additional public prosecutor was notified accordingly, post of. As the said, two accused persons who were on bail, they were allowed to remain on bail with a direction to appear before the Court of Sessions on 7/5/2010. Post of. Para. On receipt of the case records of GR case number so and so, the Court of Sessions, Tinsukia, the trial court, registered the same as Sessions case number 46 within bracket T of 2010. Post of. Though the learned trial court sought to secure the appearance of the other two charge sheeted accused persons, Arati Tati and Ganesh Tati, they could not be traced out during the trial, and the learned trial court ordered to file the case against them after execution of proclamation and attachment order. Post of. As the two accused persons, Munia Munda and Binu Mahato, appeared before the trial court, the trial court on 31/5/2010, after hearing the learned counsel for the parties and upon perusal of the materials on record, framed charges under section 302 IPC read with section 34 IPC and section 448 IPC read with section 34 IPC against them, while observing that the other two accused persons were in abscondence. When the charges were read over and explained to the two accused persons, they pleaded not guilty and claimed to be tried. Post of. Para. During the course of the trial, the prosecution side examined the following 30 number of prosecution witnesses and exhibited the following 18 number of documentary evidence to bring home the charges against the two accused persons facing the trial. The index or file table from behind him. After closure of evidence from the prosecution side, the two accused persons were examined under section 3131B CRPC by placing the incriminating circumstances appearing from the prosecution evidence against them. Post of. When the accused persons were asked whether they would adduce evidence in their support, they declined to do so. Also, after hearing the learned counsel for the parties at the argument stage, after evaluation of the evidence to materials on record, the learned trial court proceeded to deliver the verdict of guilt against the two accused persons, including the present accused appellant, by the judgment and order of conviction and sentence mentioned in E-line to T2. The one more witness was examined as a court witness. First, we have heard Mr. Ed Hor, learned amicus curiae with Mr. N. Hassan, learned counsel for the appellant, and Ms. A. Begum, learned additional public prosecutor for the respondent state. Post. Mr. Hor, learned. It is submitted on behalf of the appellant that the other accused, other convicted accused person, namely, Mania Munda, had preferred an appeal, criminal appeal within bracket J number 56 stroke 2016 53. And the said criminal appeal has already disposed of, disposed of by a judgment and order dated 11/12/2019. First up, it is submitted that the criminal appeal, it is submitted that criminal appeal J number 53 of 2016 has been allowed by a coordinate bench of this court. First up, it has been projected that both the convicted accused persons who faced the trial, were similarly situated and therefore, the same, therefore, the evidence in respect of both of them are same. Therefore, the principle of parity would be applicable in the case of the present accused appellant. It has been highlighted that it was the appellant who had gone to the house of the prosecution witnesses, PW 9 and PW 16 on the date of the incident to inform them about the condition of Dalima Dutta, who had allegedly sustained injuries on her person inside her house. Also, it is submitted that it was PW 9 and PW 16 who came to the place of occurrence at first, and the other prosecution witnesses had only followed them, but had arrived at the PO subsequently. So that's comma. The testimony of PW 9 and PW 16 are to be given utmost importance than the other prosecution witnesses. So some of the witnesses, prosecution witnesses, were close relations of the deceased. And there were embellishments and improvements in their testimony. Full stop. Insofar as the evidence against the present appellant is concerned, comma, it is submitted on behalf of the appellant that forensic report, serological test report gave negative report as regards presence of blood stains on the wearing apparel of the appellant. Full stop. All the incrementing circumstances point towards the absconding accused persons. There is lack of evidence to attract to bring in the applicability of section 34 IPC to as there was no common intention. Post op. It is further submitted that the presence of the appellant at the PO, even after commission of the offense, is a circumstance which goes in favor of the appellant, as he assisted in breaking the door of the house, comma, which was locked from inside, comma, to reach the deceased who was then in an injured condition to reach Dalimato. Post op. Para. Even the evidence regarding seizure of a hammer is also doubtful. Post op. Para. Ms. Begum, an traditional public prosecutor appearing for the state, has submitted that none of the contentions advanced on behalf of the appellant can be given credence to. Can be given credence. Full stop. It has been established from the evidence on record that the appellant who was present inside the compound of the house of the deceased from a point of time anterior to the incident of assault on Dalima Dotto. Full stop. The present appellant, along with the other accused person, Mania Munda, who were employed by the deceased to do some masonry works in her house. Full stop. The absconding accused person, had pointed towards the involvement of the appellant in the act of assault on the deceased. Full stop. The medical evidence has clearly established that the deceased met a homicidal death due to a number of injuries sustained on her person by sharp weapons, of assault, like dao, mechi dao, and full stop. Pointing towards a statement given by the appellant during his examination under section 3131 BCRPC. MS Begum has sought to distinguish the pleas taken by the appellant from the plea taken by the other accused person, Mania Munda, at the stage of examination under section 3131 BCRPC. Full stop. The circumstances established, according to MS Begum, by the prosecution, from the circumstances established. Inference was clearly drawable against the appellant as one of the perpetrators of a crime. And as such, the appellant clearly owed an explanation under section 106 of the Evidence Act. But, the appellant failed to provide a plausible explanation. And as such, the chain of circumstance was complete to draw an irresistible conclusion that it was none other than the appellant who had participated in a crime. Full stop. The MS Begum has further contended that the principle of parity would not be applicable in the case of the appellate. Also, para. We have given and have also gone through the materials, evidence, so materials on record, including the testimonies of the prosecution witnesses and the documentary evidence available in the case records of Sessions case number 7. Post document. Para. The deceased there is no dispute to the facts that the deceased was serving as a teacher in a school in Tinsukia, and she used to reside in her house, in her own house, comma, a RCC building, comma, located at Bordoloi Nagar, Tinsukia. Post stop. At the time of the incident, comma, the deceased had her husband, comma, one daughter. Who is she? PW. PW4, one daughter, PW4, and one son, within bracket PW10. Post stop. While the husband of the deceased used to reside at Dumduma at the relevant point of time, comma, the daughter of the deceased was at Guwahati on 9/8/2008. Full stop. The son of the deceased PW10 was at Chennai on 9/1/2008. Full stop. All three of them had reached Tinsukia only on the next day or thereafter. Full stop. Okay. Where is the IO?
Twenty-three.
73. though the IO recorded the statement of the house or husband of the deceased on April incident again, 9 months. 10/1/2008, comma. He testified that the husband of the deceased expired after death and he could not be brought as a witness during the trial. Page 77. Right. Full stop. Para. The informant, comma, PW1 was an younger brother of the deceased. PW1 and PW2. The prosecution witnesses, comma, PW1 plus informant and PW2 were younger brothers of the deceased. Brother-in-law?
Brother-in-law.
Okay. Sorry. The informant as PW was a brother-in-law of the deceased, whereas PW2 was a younger brother of the deceased. Full stop. PW2 and PW6 were younger brothers of the deceased. Full stop. PW7 was a younger sister of the deceased.
11.
PW7 and 8
7,
were younger sisters
7,
of the
8, and
deceased.
11.
Huh?
7, 8, and 11.
7 and 8 and 11.
11.
11. PW20 was another brother-in-law of the deceased and is the husband of PW8.
PW8.
These prosecution witnesses had arrived at the PO after receiving information about the incident from others. Full stop. Para. The prosecution witnesses, comma, PW3. Neighbors. Comma, PW5.
9. 16,
PW9.
16, 18,
1 minute. PW 12.
Tenant of the accused,
Huh?
tenant of the accused, 12. 12 is
PW
not-
12.
Yes. Bologna,
Okay.
need not to them.
13? No.
No.
Ah,
16 is neighbor,
16. PW 16.
18,
18.
19,
19.
21,
21.
20.
Were neighbors of the deceased, being residents of Bordeloi Nagar, Tinsukia. Nine. PW 12, the prosecution witness, PW 12. Who was a witness to the seizure. Who gave his signature in EXT3. Who gave his signature in the seizure list, EXT3. And this witness was declared hostile by the prosecution. Full stop. The prosecution witnesses, PW 13 and PW 14. And PW 15. Were witnesses of seizure of articles. PW 17 was the then secretary of the Village Defense Party at Guijan Market. Who gave his signature in a seizure list, EXT 10. PW 22 was a constable traffic. Who accompanied the IO to the PO and was a witness to a seizure list, EXT4, whereby CD means compact disc. A compact disc CD was seized. PW 3 was serving as a senior medical and health officer at Tinsukia Civil Hospital on 9/1/2008. and at 3 PM on 9/1/2008, the disease was brought in an injured, no, disease was very dead, no? Disease- Nalini Dutta was brought in an injured condition. At so and so, he examined. Nalini Dutta was brought in an injured condition. Close to. Seizure witness report is PW 24 to analyze. Seizure witness of 24 to of my duties. PW4 was a photographer. In the CID, PW25, who prepared the compact disc, seized by EXT4, seizure list, EXT4, and which was, and packet of it up to go, Math EXT4. Close to. PW26, was serving as demonstrator, in the Department of Forensic Science, Silchar Medical College and Hospital. And he performed the postmortem examination on the dead body of the deceased on 10/1/2008. PW27 was the IO. A seizure list all over. It was a seizure witness to a seizure list. Police constables কৰি দিব PW এটা আছিল না আৰু লগতে PW28 25 and 28 20 no seizure list compact disk no I distinguish between compact list seizure and CD2 PW25 and PW28 were police constables and they were witnesses to the seizure. They were witnesses in the seizure list, EXT4, whereby a compact disk within bracket MAT EXT MAT-EXT4 was seized. Photographer, no? 29 to come. Yes. He was my mother's sister. Oh, I got to PW29 was a niece of the deceased. I know I got a relation to the below 30.
Dog instructor.
Was a dog master of a sniffer dog. Of the CID and served in the DEF, Dibrugarh at the relevant time. Post. আরো আছে এটুকুন the court witness নালাগে একটু উঠাও পেরা Ajoy Kumar Das, a sub-inspector of police attached to Tinsukia Police Station, deposed as CW1 to exhibit an entry in the general diary, general diary entry number 335 recorded at 2:45 p.m. in the general diary book of Tinsukia Police Station, full stop. From the testimony of CW1, it has emerged that at 2:45 p.m., one Dr. M.K. Borua telephonically informed the police station that near the house of one Ellen Borkotogi, an advocate, some miscreants had inflicted cut injuries on a lady and she was lying at the spot. Full stop. On receipt of this information, the general diary entry was made, and a team of police personnel led by PW7, the officer in charge and the IO, officer in charge of Tinsukia Police Station and the IO, along with a team of police personnel proceeded to the PO. The general diary entry number 335, dated 9/1/2008, was exhibited as the general diary book of Tinsukia Police Station was exhibited as MAT-EXT1, and the general diary entry number 335, dated 9/1/2008, was exhibited as MAT-EXT within bracket 1, post para. From the testimonies of the prosecution, witnesses, it would emerge. It is found out that it is the prosecution witnesses, PW9 and PW16, who received the information regarding the alleged assault on the deceased at first. So therefore, it appears apt to examine their testimonies at first. First of PW1, 9 and PW16 are the husband and the wife respectively, and their house was located nearby the house of the deceased. In his evidence in chief, PW9 deposed that at the time of the incident, he was in his house at the time and date of the incident. He was in his house, full stop. At that time, masons were working in the house of Dalima Datta. Full stop. One mason working in the house of Dalima Datta tried to draw his attention by shaking the lock, by shaking the gate of his house and informed that Dalima Datta had a fall. Full stop. On being so informed by the mason, he came out of his house and proceeded to the and reached the front of the house of Dalima Datta. Full stop. He indicated presence of other persons there. Full stop. Going there, PW9 found that the front door of the house of Dalima Datta was closed from inside. Full stop. Then he tried to open the door, seeing blood flowing under the door. Full stop. Then, he asked the appellant, named Binu, asked the appellant, who had gone to inform them, to bring a crowbar. Full stop. The appellant then brought a crowbar to hand it over to PW9, full stop, with the said crowbar, no, we just full stop. PW9 testified to have opened the door by dealing blows with the crowbar. Full stop. After breaking open the door, he found Dalima Datta lying in a pool of blood near the door, with cut injuries on her head, face, nose, and other parts of her body. Full stop. She was alive at that time, and seeing them, she tried to stand up and managed to drag herself out to the veranda. Full stop. PW9 stated that when he inquired, Dalima Datta replied that she had been assaulted. Full stop. But, she could not utter anything more. Full stop. The brother-in-law of Dalima Datta and some other persons arrived at the PO, and it was decided to take the injured to hospital. Full stop. PW9 testified to have seen Aroti, the housemate, who was then working in the house of Dalima Datta, there, and when Aroti was asked where from she had come out, she replied that she had come to see Dalima Datta. Full stop. PW9 stated that Arati had a bag in her hands at that point of time. Full stop. Later on, they could not find Arati at the place. Close to. PW9 further stated that a hammer and a dao were found inside the house of the deceased. Close to. Police personnel went to the house of Arati and made some seizure, made seizure of clothes from our house, wherein he gave his signature. Post up. According to PW9, blood-stained footprints of Arati were found inside the house. Post up. During cross-examination, PW9 stated that he did not know the names of the masons. And he saw 4 to 5 masons working in the house of the deceased. The house of PW9 is situated on the right boundary, on the right side boundary of the house of the deceased. He denied a suggestion that he did not state to police that it was the appellant who brought the crowbar and gave it to him. PW9 reiterated that when he arrived at the PO, he found the doors and windows of the house of the deceased closed. PW16 is the wife of PW9 and she had earlier given her statements under section 164 CRPC, which she exhibited as EXT9 with her signatures therein. In her testimony, PW16 stated that at around 1-00/1-30 PM on the date of the incident in January 2008, one mason named Munda working in the house of Dalima Dotto came to their house and made sounds on the iron gate of their house, pleading them to come out as something had happened to Dalima Dotto. Then she, along with her husband, PW9, went to the house of Dalima Dotto and going there, her husband PW9 tried to open the front door of the house of Dalima Dotto as the door was kept locked from inside. Though initially her husband could not open the door, but later on, with a crowbar, handed over to her husband, her husband opened the door. After breaking open the door, Dalima Dotto was found lying in a pool of blood near the door. And Dalima Dotto asked her to give water. But seeing blood, she ran out of the house. PW 16 stated that after some time, the family members of Dalima Dotto arrived at the PO and took her to hospital. PW 16 further stated that after opening the door by opening of the door by her husband and other persons, she saw the housemates of the house in a corner of the veranda with a bag in her hand. When Arati was asked by her as regards Dalimi Dotto, Arati suddenly left the place. PW 16, like PW9, stated that when Dalimi Dotto was asked as regards she replied that she had been assaulted. PW 16 further stated that at the time of occurrence, construction works were going on the first floor of the house of Dalimi Dotto. When cross-examined, PW 16 stated that there was a door on the grill of the front veranda and the door used to remain closed. She denied the suggestion that she had deposed falsely. That she saw the two accused persons working as masons in the house of Dalimi Dotto. From the testimony of PW 1, it can be noticed that he arrived at the PO after informing about the incident telephonically. When he reached the PO, he found his elder sister, Dalima Dotto, lying on the veranda of her house in a pool of blood, with injuries on her face, hands, etc. Though Dalima Dotto was alive at that point of time, but she was not in a condition to speak. It was with the assistance of PW6 and PW20, Dalima Dotto was put in his vehicle and he then took her to Tinsukia Civil Hospital at first. After preliminary treatment at Tinsukia Civil Hospital, she was taken to Brahmatra Nursing Home at Dibrugarh and PW 6 and PW 20 were with her. Pusta. PW 1 stated that Dalima Datta expired on 9/1/2008 itself. Pusta. He further stated that Dalima Datta used to stay alone in the house. And the maid servant and the housemate, Arati Tati used to do her works in the house of Dalima Datta from 6 a.m. to 8 a.m. Full stop. He further stated that at the time of occurrence, masons were also working in the house of Dalima Datta. Masons, named. We are not assistant, we will skip that. Binu Mahato and Munia Munda were working in the house of Dalima Datta for plastering works on the wall outside the drawing room. Full stop. He found a bloodstained dog lying inside the drawing room. Full stop. He suspected, PW1 suspected the masons behind the suspected the act of the masons behind the incident for a reason that despite the incident, they were working, they were busy with their masonry works. PW1 further stated that after sending injured Dalima Datta to Dibrugarh, he lodged the FIR at Tinsukia police station and he exhibited the FIR as EXT1 with his signature therein. Full stop. He also identified the seized dhow as Matt EXT1 and a seized pair of footwears as Matt EXT2 and a seized hammer as Matt EXT3. So he further stated about use of sniffer dogs during the investigation. Post-op. PW1 admitted that, stated that the house of PW16 is to the right of the house of Dalima Datta. Post-op. PW15, he stated that PW15, he stated that PW5 was another neighbor of Dalima Datta. PW1 further stated that house of Dalima Datta is a RCC construction and there are boundary walls around the house with a gate in front of the house. The veranda is protected with grills. He stated about presence of PW3 and PW19 at the PO at the time of aftermath the incident. Post-op. Like PW, we'll continue tomorrow because some other matters are listed before. You get partner to Kaligani. Mr. Oh, you had, can't help it. Take it. Choose it. Take it. More. Pattern.